So earlier I asked you guys, like if you understood this idea of like when a judge makes a decision, how they're shaping public policy. And Abby said that they're setting a standard. Well, really, you're absolutely right. And that word that we use, like in terms of standard for the court, is called a precedent, okay? So if you remember, we're really, at this point, we're just going to talk about the federal courts because that's, even though like most activity happens in the state courts, the process is going to be the same, but we're really trying to study American system of government, so we need to understand the impact that the Supreme Court has been on the states. So this diagram, this is a diagram of our circuit. Okay, so remember the circuit was the second level in the federal court system. So it goes district court, then circuit court, then Supreme Court. So the United States has been split into all of these circuits, and you can just see by, like on the screen, the numbers that they have. So we are in the Fifth Circuit. So if we go back to David's case where he was arrested for robbing a bank, when he appeals, he's going to appeal in the Fifth Circuit. And let's say that they decided in that case that David's rights were like gravely violated. Okay, they're like, this is not right. The Constitution says you deserve a competent, fighting for your right attorney. Okay, and they're going to set him free. What that does then is that says to every lower court in the Fifth Circuit, that's what you're supposed to do. It establishes a precedent. Okay, you can imagine then that sometimes the circuits don't always do the same thing. How did we say in our last unit? What is one of the major influences on one becoming a federal judge for the lower courts, like the district court or the circuit court? Technically, the president appoints them and the Senate confirms them, but in practicality, what's happening?
Like, wasn't there something where it's like your friends, the
Patronage. Kind of. Who is it that's approving federal judges? Remind me. The Senate. So, do you think the Senate might play a role in lower court judges?
Yeah.
What do we call that thing? So nice. So kind. Senatorial courtesy. Very good. So, senatorial courtesy, remember we said that senators from the states get to influence who those federal judges are going to be. Well, you guys, that means then that we're going to have differences in those judges in terms of their perspectives. We're going to have a lot of regionalism, just like we do with political parties, because we're going to have a certain kind of mentality in one area of the country and another. So, like, you guys, the Fifth Circuit and the Ninth Circuit frequently are conflicting. Like, we frequently make decisions that are not the same. There have been many cases where the Seventh Circuit and the Fifth Circuit have not been, like, aligned. Each of the 9 justices on the Supreme are more of the circuits. So while even they're serving on the Supreme Court, they also are kind of like paying attention to what's going on in the circuit, and it allows them to see like if something like that's happening. Like if we got a situation where we've got some kind of conflicts between the different circuits. Okay, whoops. All right, so you asked me earlier what certiorari was, okay? So you can say that word certiorari or certiorari. It's like a tomato word. From this point, I'm going to say cert because I hate saying it, okay? So we want to focus on this idea of the cert process. All a writ of certiorari means, a writ of cert means, is that the Supreme Court is going to agree to hear your case. Okay, and we're going to work through some statistics so that you can understand the volume of work that the Supreme Court is asked to do versus what they really do. Okay, I think that this is a good way to kind of think about it, though. The Supreme Court doesn't just take a case because. They don't take a case just because they think, maybe that person didn't quite get like a fair deal. There's got to be something that like is overwhelming for them to really take up your case and devote the amount of time that's going to end up being devoted. Don't write this down. I just wanted to show you some statistics. So in an average year, between 8,000 and 10,000 applications for certiorari go before the Supreme Court. And they're going to hear, on average, less than 100. There are 2 categories, which I thought were kind of interesting. It costs you $300 to file your petition with the Supreme Court. So if you can't afford that, though, you can file what's called an IFP petition, which means that you're too poor. And a lot of times those are people that are in prison, you know, because they can't afford it. And so a lot of paid petitions are going to be filed by corporations, you know, like businesses, that sort of thing, whereas IFP petitions tend to be like more criminal. At the end of the day, though, that is not the majority. of the cases that we're taking. The majority are coming from those paid petitions, and there's a lot of things we could talk about in terms of why. That doesn't mean that these IFP petitions haven't been taken up. We're going to look at a lot of the cases that we look at that establish criminal rights were filed that way. I mean, you guys, like, people, like, writing on, like, notebook paper, like, with the prison stamp on it. Like, the court has totally taken up cases like that. But I think at the end of the day, we've established a lot of those rights, and so now we're kind of looking at more issues of, like, technology and corporations that don't necessarily involve the rights of the accused all the time. So here's what's going to happen. All of the justices have what are called clerks, and they get 4 clerks. Clerks are just people that work for them. Like, they've graduated from the very best law schools. The justices get to hire their own clerks. So they're going to hire people who are like-minded, probably people who are educated in the same place, so they feel like they're going to be able to make a decision. And then the clerks are going to read through those petitions. So the justices require their clerks to read all 10,000 petitions. Some of them allow them to participate in this pool and kind of like cooperate and share the work, so it just depends on who you work with. Then what they're going to do is they're going to create these lists that are going to go to the Chief Justice. The discussed list means we are going to consider taking the case. It doesn't mean they're going to take the case. It doesn't mean they're going to make a decision. It simply means they're going to consider it. This is so important, the second bullet. If the Solicitor General files a petition for certiorari, it automatically means that that case will end up on the discussed list. So the Solicitor General is somebody that works in the executive branch. Think back to the Cabinet. Department of State, Department of Defense, Department of Justice is the number 4 person in the Department of Justice. So they're really high ranking. They are considered the liaison between the executive branch and the Supreme Court. Your textbook dubs them the ninth and a half, why can't I say that? The 9th and a half justice. See, I prefer to call him the 10th justice because that's way easier to say, and I've also heard other texts and other authors call them that. So it's not saying that they're on the court, you guys, but their link is very, very tight. If we're going to argue, if somebody from the federal government is going to argue before the Supreme Court, the Solicitor General is the one that does it. The Solicitor General is the one that writes amicus briefs. So, like, every decision that the Supreme Court makes, the Solicitor General, like, has a link to them and has an opportunity to try to influence. If somebody stands to lose their life, they automatically put that case on the discussed list. So if somebody's facing the death penalty, we're going to consider it. Doesn't mean they're going to grant their appeal, but it means they're automatically going to consider it. Certiorari conferences are done in secret. When I say they're done in secret, it just means that there's no recording. No clerks are there. It's the 9 justices sitting in a room, door shut. And how they have those conferences is truthfully just up to the Chief Justice. It's like, what do they want to do? You know, and they're like a manager of the court, and so they can decide like what protocol and how things are going to be done. And I think it's really important. Like, why do you think it would be important for the certiorari conferences to be done in quiet, like that nobody else is there? And do you ever change your mind after you talk to people?
Yeah.
So I think that that's the thing. You know, like, I don't know if you've ever, like, gotten in a fight with a loved one before, and they're like, well, you said in the past, blah, 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 because you changed your mind, right? Well, imagine the Supreme Court if there's a record of that. You know, if a justice used to think one thing, but after discussion, they're like, you know what, I've changed my mind. I think the thing is they need to be able to do that openly. They need to be able to have these, like, academic, very honest discussions where they can kind of consider both sides. And, you know, some people are out loud thinkers, and some people are far more pensive and quiet, but at the end of the day, they need that opportunity. So all we get is we get the result of the vote. And this is all we know. We know if they're going to grant cert or not. It's considered the rule of 4. If 4 of the 9 justices say to grant cert, we grant it. We don't actually know, like, how many said it. We just know that at least 4 did if they agree to hear the case. The reason they went with 4, obviously, is they wanted to prevent that idea of tyranny of the majority. Remember, that was a huge thing to our framers. And so that's just kind of how we are. Like if one of the justices is really, really mad, they can issue that, which is a public record of them saying, I think we should have granted cert, but it's like really,
showing their vote.
yeah,
They really care about it.
yeah, so they'd have to be really, really mad.
Would that change anything, or?
No. It's just like a public record that they want it, like, they want it on record that they didn't agree.
Oh, that kind of makes sense though.
So what we're going to do is I'm going to go through some factors. Like, there's no, like, rule book. Like, we don't know, like, okay, this makes them take the case, this doesn't. But academics that study the court can say, well, these are the trends that we find. So we're going to go through a list of some things that might cause the court to take your case. And then what I'm going to do is I'm going to give you guys some sample cases, and you're going to decide, do you think they would grant cert or not? I'm going to give you some opportunity to kind of talk through the list, okay? So you're going to want to take the stamp. You're going to want to know this, okay, because you don't have this in front of you. You need to look at these things. So on the left-hand side, what might cause the court to take up your case? Well, an obvious one to me is if you've got circuit conflicts. Remember, we looked at that map originally and we said we in the 5th Circuit might not agree with what's going on in the 11th Circuit. That doesn't mean that just because there's a circuit conflict, they will take up your case. You guys, some circuit conflicts are okay. You know, like regionally, we are different. And so the court accepts that. I think what they have to decide is it an acceptable conflict or is it not? Is it something that's super fundamental, like freedom of religion or rights of privacy? Or is it something that maybe isn't as big a deal and it's okay to be applying the Constitution differently? If we have a lot of amicus briefs, then that might cause the court to take up a case. So Arvin, remind me, what's an amicus brief? Amicus curiae. You remember that?
It's like in case you couldn't meet someone in the court.
Close. Yeah, you're definitely on the right track. Who is it that writes the amicus curiae brief? Do you remember? Like what linkage institution do they come from? The Solicitor General can write them for sure, yes. But typically, when we learned about them before, who did we say might write those?
Clerks?
The clerks will read them.
Yeah.
The NRA, Mothers Against Drunk Driving.
Oh,
Yeah.
the interest group.
Right, good. So lobbyists working for interest groups write those amicus briefs. We said that they write those because they're unable to directly lobby a judge. So what they can do is they can try to influence a judge. But you guys, they also can try to influence them to take a case. So they can write amicus briefs to try to persuade for cert, and then they can turn around and write them to try to influence the decision as well. I've heard interviews with the justices, Justice Souter, who's retired now. He said they really do matter. Because if there's something out there that there's clearly like a lot of controversy or public opinion is brewing really hard, then the court takes that seriously, that they're like, this is something obviously we need to settle because there's like unrest or discontent in the country. If it's a case that affects a whole lot of people, or if it's something that's just really unique. The example that comes to mind for that is the Bush versus Gore case, where we had to look at the election results of 2000. The Supreme Court couldn't have said, sorry, we're not going to take that. Like we needed a decision so we could get a president. So there are some situations like that where they feel like they have to. Korematsu versus the U.S. Like they have to make they have to do that, you know. Why might they not? There's a lot more reasons to not than to grant, okay? Remember I told you earlier that when we think about that circuit map, that the justices oversee a circuit? Well, they might know that there's a better case coming. So the example I would give you is that this summer, you guys know that the Supreme Court made a decision on same-sex marriage, right? Okay? That's not the